Justice Kagan?
Mr. Tripp, the questions you've been getting, is there enough consent? Is there enough notice? I presume, tell me if I'm wrong, would those questions apply just as well to any 1983 suit against a state employee?
I mean, I think a lot of the notice questions are going to the sort of spending clause layer, which...
Yeah, but of course 1983, we've said, applies when a statute is based on the spending clause power. We said that most recently in Tlefsky, and there are other cases. So if we take ourselves out of the RLUIPA context for a second, we just put ourselves into the context of some other spending clause statute which doesn't have its own cause of action, but where the cause of action is 1983, presumably you would have the exact same questions about, I don't know, does the state employee know about this? Has the state employee consented to it? And yet we've never thought about those questions in that context, have we?
That's right. I think you don't ask that follow-on question. And there was no additional question about notice in Salinas. There was no additional question about notice in Sabry. I don't think there was either in Dixon, Hess, Laudan. Like as you run down the line.
Yeah, I'm just sort of saying that out of the RLUIPA context, just 1983 statute, the 1983 statute used to enforce spending clause statutes. I mean, we just take for granted that of course you can bring a suit against a state employee.
That's correct.
And then it's like, why would the rule be any different under RLUIPA?
I don't think it should be.